Okay. Good. I guess it's still morning. Good morning, everyone. I'll give everyone a chance to put their video on. Those who are registered as panelists, and including me. There we go. Back again. All right. This morning, we have the BlockFi's, actually the motion 12th omnibus objection to claims filed against the BlockFi Wallet LLC. My understanding from reading the submissions is that we're focused today on claims against BlockFi Wallet LLC by those who seek distributions beyond the digital assets held in BlockFi Wallet, or those who still contend that they had transferred funds into the wallet from their investment accounts. There have been a limited number of responses. I have the wind down debtors reply in response to certain responses, as well as the initial amended certification of Mr. Chila in support of the wind down debtors motion. Let me turn to the wind down debtors counsel. Who's going to run with it today?
Good morning, Your Honor. This is Kenneth Auletta Brown Rudnick, counsel for the plan administrator. My colleague or my co-counsel, Lauren Sisson, will be handling the merits of the 12th omnibus objection, but I wanted to just address two preliminary issues.
Sure. Go ahead.
First, there were two objections filed by the Archesino firm, and Jason Archesino specifically. Mr. Archesino does not appear to be admitted in New Jersey, and we notified him of that. We're prepared to go forward with the objections on the merits, but we wanted to highlight that issue for Your Honor. And, relatedly, and to give some context to, or avoid any impression we're trying to leave out context to the first point, Mr. Archesino requested separately that BlockFi be sanctioned for attempting to utilize the court to commit additional fraud. To the extent there's anything that needs to be discussed about that particular claim, I request that we handle that after we handle the merits of the 12th omnibus objection.
I think that makes the most sense. To my knowledge, we have not received a request by that counsel for presenter status, nor would we likely have granted it given this his admission issue. But let's proceed.
Okay, and with that, I'll turn it over to my co-counsel.
Good morning, Ms. Sisson.
Good morning, Your Honor. Lauren Sisson of Haynes & Boone for the plan administrator. We're here today on the wind down debtor's 12th omnibus objection to claims filed against BlockFi Wallet LLC, which is at docket number 1878. As a preliminary matter, we'd ask that the declaration of Mr. Chila in support of the objection be admitted, and that's at docket 2009.
Well, all right, without objection, it's admitted. Thank you. Good morning, Mr. Chila.
We received 24 responses that were filed through the Kroll portal, and then 2 responses filed directly on the docket. Those are at docket numbers 2033, 2027, and 2028, respectively. As you recall, Your Honor, the wind down debtors filed this objection to about 12,000 proofs of claim that creditors had filed against debtor entity BlockFi Wallet LLC. And those actually comprise about a third of all of the proofs of claim that were filed in the case. The wind down debtors filed the objection seeking to expunge those claims pursuant to the court's ruling in May that funds in wallet are not estate property and that BlockFi could allow creditors to withdraw the funds in the wallet portions of their accounts. The expungement of these claims will not affect the ability of any creditor who filed a proof of claim contained in this objection to receive distributions on any scheduled claims that they have against BlockFi Inc., BlockFi Lending, or BlockFi International. What expunging these claims will do, however, is allow the wind-down debtors to complete the claims reconciliation process much more quickly as we move toward making initial distributions to creditors. We received 26 total responses to the objection, which we summarized in our reply that was filed at docket 2034. To the extent a response contained a question or a creditor seemed to misunderstand something, we did reach out by email to attempt to provide clarity, and we were able to resolve a number of the responses. I will not go through each individual response, but if the court has any questions about a particular response or the objection generally, I'd be happy to answer it. Otherwise, we would request that the court sustain the objection and enter the proposed order allowing the wind-down debtors to disallow and expunge the claims on Schedule 1 to the objection. Thank you, Your Honor.
Thank you, Ms. Sisson. The court is satisfied that the process that we put in place as far as being able to administer and entertain the objections has worked remarkably well, given the thousands of claims that were filed and what was boiled down to a few dozen responses. I think the process offers meaningful transparency for parties and interested creditors and an understanding of what's at issue. Here, what's at issue is we have a debtor entity that has no assets, no creditors, and claims against these entities serve no purpose. The rights and the ability to pursue claims against BlockFi Inc. and other related entities that will have assets for which there will be some distribution are retained. We need not also relitigate or offer the opportunity to relitigate the platform pause issues for which a considerable amount of time, effort, and money was spent with respect to its resolution. I am satisfied that these claims should be expunged, that such action is necessary to move ahead with distributions, which are long awaited. Our chambers and your offices have received a substantial number of emails from individuals looking for distributions, looking for access. The wallet holders have had access. Those that did not have digital assets in the wallets are not entitled to any return beyond their distributions as general unsecured creditors. That's contemplated in the future. So with that being said, based on the wind-down debtors' responses and Mr. Chila's amended declaration, the court will grant the objections in toto and we will overrule any objections. With respect to Mr. Allet's reference to counsel's cross motion or motion for sanctions under Rule 9011, there's no basis in fact or law to support that, and procedurally it was improper. If counsel wishes to file a new motion seeking sanctions, counsel certainly has that right, but should be guided by the requirements under Rule 9011 and the substantive law with respect to applicability, and that such motions themselves can be reviewed under Rule 9011 for propriety. So with that being said, do I have a final form of order, or will you be submitting one?
The proposed order that was filed is the order, but we can submit it again to chambers directly if you prefer.
We'll have it. If we need it, we'll reach out for you. With that being said, I don't believe we have anything else on for today's calendar. I did want to discuss the 11/16 calendar with I think it's the 7th omnibus objection, in which we can anticipate some substantial involvement by claim holders. Needless to say, I'm reluctant to open the Zoom process to the remote process to a freewheeling town hall forum. And I wanted to hear your thoughts.
Your Honor, in regards to the 7th omnibus, there's actually only one claim that we've adjourned several times that's going to be heard. So I'm sure I know counsel for that claimant, and that claimant himself will likely be on the Zoom. But what I suspect you may get a number of requests for are possibly the claim capping motion that's on for that day, which is the other matter. Right. Okay. We're referring to Mr. Vandenbergen. Yeah. That I've seen, and there were recent filings. So that's the one contested matter. And then we have the other matters with respect to, I'm sorry, how do you reference it? We have a motion to cap the claims. Capping the claims. Yeah, that does contain, it was served on about 18,000 creditors, so your chambers may be getting presenter status response requests for that. Right, and obviously we don't have the capacity to hear from thousands of individuals. Arguments are likely to be repetitive from what's already in their written submissions, which the court has already seen based on the portal. I'm inclined, and I need to be fair, I can't let the debtor have oral argument and not permit, or the wind-down debtor permit respondents the same opportunity, but yet the volume of respondents and the repetitiveness will impede administration of the case. So I'm inclined to do it just simply on the papers, but I also wanted you to hear any thoughts on that, if there was a need to have more than just submissions on papers.
So, Your Honor,
and you can think about it. You don't have to give me an answer today, but we need to prepare.
Yes, Your Honor, I can address the capping motion. As you are aware, there were a number of objections filed to that. A large number of those objections are non-substantive or don't even contain an objection. I think we would be happy to move forward on the papers. We expect to file a reply that will categorize those objections and address each of them largely by category. I should note that there will be one substantive change that based on a negotiation from an informal objection by Ancora Trust Company. We will be proposing additional language with respect to the capping of their unsecured claim at zero. We have resolved that issue with them, but to the extent that Your Honor wants any discussion on that, we could always have discussion on that. I don't believe that any other objections that were filed require oral argument.
Let the court have the opportunity to review the reply, and then I'll decide on what makes sense practically and equitably as far as how we move forward, whether we have it on the papers or a limited oral argument. When do you anticipate filing the reply?
I believe we anticipate filing it tomorrow, and we're working on a submission of all of the objections that can be docketed. However, as Your Honor may have noted, some people uploaded identification documents, other information that requires very careful scrubbing to make sure that we don't post anything publicly that shouldn't be posted. So we'll get that on file as quickly as possible.
All right. Once you do that, the court will make a decision, probably enter a text order on how we move forward. All right. I appreciate all of your efforts. Thank you. Is there anything else anybody needs?
No, Your Honor.
All right. Take care then. Thank you. We are adjourned.